Hi everyone, I am Lilian Chukura from Lily Legal, where we help our clients get status for themselves and for their families using the US immigration law system. So today I want to talk to you about an exciting update to VAWA requirements. So if you have been watching my videos for a while, you know I love talking about VAWA. I have several detailed videos on VAWA. So you can go ahead and check those out. But there has been an update, and I really want to go over that with you because some people thought they couldn't apply. This update may make a difference to whether you can apply for VAWA or not. Okay, so if you have any questions, go ahead and put them in the comments. If you would like to book a time to talk to me, you can do that by going to my website, lilylegal.com, or by calling my office at 508-443-1788. Okay, so I'll give you a scenario. So you're married to a US citizen. You two have been married for a while. You're now separated. During the marriage, you suffered abuse, right? You two got married within a month of the marriage. There was already issues and there was abuse. Um, the US citizen spouse is abusing the non US citizen spouse. But something else that happened was that you two stopped living together, right? So you were living together before marriage, you two got married, abuse happened, you were out. So during the actual marriage, you two never lived together. And before this update, you were out of luck because you could not prove that you two lived together during the marriage. And therefore, you would not qualify for VAWA. Well, USCIS has changed that through the reauthorization of VAWA. So every few years, when VAWA expires, Congress has to reauthorize it. Congress basically goes through the VAWA rules, decides if anything needs to be changed, negotiates that whole process, and comes up with the final rule. Sometimes it causes a major change in VAWA, and sometimes it doesn't. They just reauthorize the same rule. Well, this time around, they did not just reauthorize the same VAWA rules. They actually added a special provision for people that, unfortunately, for one reason or another, did not live with their spouse during their marriage, right? But the abuse happened during the marriage, but they did not live with the spouse during the marriage. Well, the new rule says that USCIS is no longer requiring that self petitioners reside with their abuser during the qualifying relationship. So, what does this mean? This means that if you did not live with your abuser during your marriage, during the qualifying relationship, which would be the marriage, if it's a spousal VAWA petition, then you can still apply because if you lived with them at any point, right? At any point before you file your VAWA application, you can still qualify. So let me repeat that. If you lived with your abuser at any point before you file your VAWA application, it will count, even if you did not live together during the qualifying relationship. So let's say when you two were dating, you lived together and then you stopped living together, decided to get married, but never actually moved back in together because of um, because of the abuse or because of other reasons. However, the abuse took place while you two were married. Now you can use the fact that you two lived together while you were dating to meet the requirement of joint residency. Okay, so this is huge. This is huge. And I wanted to cover it with you all today because it makes such a huge difference. I have seen this like literally stop someone from being able to qualify for VAWA, right? They live together with their significant other before they got married. Then one person moves, or a job takes you somewhere else, and you never actually got back to living together. Well, you can still qualify for VAWA. So this is a huge change in the rules. So some people may not see that as a big um, change, but it really is. So imagine if you're a child filing based on an abusive parent. So your parent was abusive to you. Your parent is a U.S. citizen or permanent resident, and you qualify for VAWA. But the parent that was abusive to you, you never actually live with them, right? Let's say it's your non-custodial parent. So you never actually lived in the same household with this parent, but but they were still abusive to you, and you can prove that abuse. Well, now USCIS does not require that when the abuse took place that you lived with your parent. So let's say you live with your parent when you were younger, and now the abuse took place when you were older and your parents were separated and all of that. Well, guess what? It still qualifies, right? Because you lived with your parent at some point. Okay. So that is huge, 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 huge. Because I've seen parents that were abused, but the abuse took place after the child moved out, and they think they can't qualify. Well, now they can, because the abuse didn't have to take place while you were living together. Okay. The abuse does not have to take place while you were living with your abuser. It can take place later, but you still have to meet all the other VAWA requirements. So it's really important that even if you're not living with your abuser presently, or you didn't live with them during your marriage, or during the abuse itself, but you lived with them at some point, even if it's after, right? Let's say you two separated, the abuse stopped, and you decided to move in together, that would still count. So it is huge, huge. And it's so important that when things are reauthorized, that, this push from activists to get these little changes that can make a huge difference in someone's life. Okay. So this is a huge change. If you have questions about it, put it in the comments. I am happy to answer questions, because this is such an exciting thing that took place. And this took place recently because they just reauthorized it this year. Okay. So, like I said, VAWA is a law that was passed by Congress. So therefore, it needs to be reauthorized. It can be reauthorized after a certain number of years. So when it is reauthorized, they can make changes, little changes, big changes. It's really up to Congress and their negotiations to decide how big of a change to make, if changes are required. Sometimes they just reauthorize the same bill without changing anything. And this time around, they didn't do that. They decided to actually make a change that to some people may not seem significant, but to those that need to file for VAWA, it is very, very significant. So, like I said, if you have questions, put them in the comments. I'm happy to respond to those. And I'm just going to put this back on the screen. So USCIS no longer requires the self-petitioner to have resided with the abuser during the qualifying relationship. Okay. So you don't have to reside with them during the qualifying relationship, but you still have to reside with them at some point, right? Either before the qualifying relationship or after the qualifying relationship, but you have to reside with them at some point, in order to meet the residency requirement, but not during the qualifying relationship. This is huge. So, Like I said, if you have any questions, go ahead and ask them, because um, sometimes it's hard for people to understand the little differences here. So I am happy to talk about those. Now, I just want to go over the general requirements for VAWA and where this will fit into those general requirements. So, in order to do a VAWA self petition, so it's called a self petition because you don't have a petitioner. You are applying for VAWA on your own, right? No one else is filing for you. You are applying on your own based on you meeting certain requirements, right? Your spouse, your parent, your child, they do not have to be aware that you are filing this petition. They do not have to be involved in you filing this petition. So that's why it's called a self petition. And the person that files for VAWA is called a self petitioner. So, to qualify, one, the self petitioner must be a spouse, intended spouse, or former spouse of a U.S. citizen or lawful permanent resident. So let's break this down. So, spouse, you're still married to the person. Intended spouse, so this means you two got married, but your marriage was not legal because your US citizen or permanent resident spouse was still married to someone else. And you didn't know this. They knew they were still married. You didn't know. And they still went ahead, went to City Hall, did the whole marriage. You thought the marriage was legal, but it turned out that it wasn't. Okay. So that's what they mean by intended spouse. So even though you're married, your marriage is not seen as valid because your spouse was married to someone else. So if you are the one that was still married to someone else, unfortunately, you are not considered an intended spouse for VAWA purposes. But if your US citizen or permanent resident spouse was still legally married to someone else when you two got married and you believe that your marriage was legal, then you would still qualify for VAWA. From a spouse. So this is where you are now divorced or your spouse passed away. You can still file for VAWA as long as you do it within 2 years of the relationship ending. So of the marriage ending. So that doesn't mean within 2 years of you two separating and no longer living together. No, between within 2 years of a divorce or a death. That's what they're looking at for that. So even if you're separated, that is not considered ending the relationship. So even though you two do not live together, it's not considered ending the relationship because you're still legally married. Okay. So once that legal marriage ends, you have 2 years to file for VAWA or you'll be out. So, spouse, intended spouse, former spouse of US citizen, or lawful permanent resident can apply for VAWA. Children of US citizens and permanent residents can apply for VAWA. Parents of US citizens that are 21 years old or 21 years old or older can apply for VAWA. So that means if you're a parent and you want to apply for VAWA based on abuse you suffered from your child, one, your child has to be a U.S. citizen, and they have to be at least 21 years old. Okay, so why is that, right? You were like, why does that have to be a requirement? Well, one, for a child to file for a parent, they have to be 21. That's U.S. laws. So if your child is not 21, there's no abuse, and they're US citizens, they can file for you once they turn 21, right? If your child is not a US citizen, there's no law out there that makes it possible for a non US citizen to file for immigration benefits for their children. So that's for their parents. I'm sorry. So that's why that requirement is there for a parent of a US citizen to get status through VAWA. The US citizen child has to be at least 21 years old. Okay. So that's the first part. Now, if you are filing as a spouse, intended spouse, or former spouse of a US citizen or permanent resident, you also have to show that your marriage was entered into in good faith. So I did a whole video on good faith marriage and how to prove it. But what USCIS is looking at here is that you and your spouse actually intended to live together and build a relationship, build a life together. And you show that by showing basically the same type of documentations you would show if your spouse was the one filing for you to get status. Okay. So that's what USCIS wants to see, is that you two were in a relationship, are in a relationship, and that um, you did plan on building a life together. You did take steps to build a life together. It's just it didn't work out. Okay. So USCIS really wants to see that you entered into the marriage in good faith in order for you to get VAWA through that relationship. Okay. The next thing is you are eligible for a visa, right? So you as a person still needs to be eligible for a visa, because if you had let's say misrepresentations in the past and all these other things going on, you may not qualify for a visa. Um, so sometimes that can be an issue, and that's something you should be talking to a lawyer about, because you want to make sure that whatever it is that you're doing, that you are getting the right information, making sure that you qualify and you meet all the requirements. You have to show that you reside or resided with the abusive US citizen or permanent resident. So that's where the new update comes in, because now you living together with the US citizen or permanent resident does not have to take place while you're in that relationship. So this is really for, I feel like this will make so much difference for people that live together with their significant other before they got married, and then got married, never lived together, and suffered abuse during the marriage. So those people that never lived together with their spouse during the marriage but live together before the marriage can still get VAWA. So that is the big, big update on that requirement. You have to show, right? The next requirement is you have to show that you are a person of good moral character. That means you don't have, a 10-page rap sheet, right? You're not deportable. You haven't done any serious crimes. You have been good. You have paid your taxes. You have, you don't have a criminal history, or at least if you do, it's minor things that are not, major. So, where does this come in? What I typically do for my clients when it comes to good moral character, we go ahead and do an FBI background check and send that in with the application, because listen, if you don't do it, USCIS is still going to do it. Okay. So when you file for VAWA, when you file all these applications, there is going to be a background check done. And me, when I'm working with clients, we want to know if there's anything that will show up, right? If there's anything that's going to show up on their FBI background check, because if there is, we can make the arguments up front that this wouldn't stop them from being eligible for VAWA. If you do not disclose that you have a criminal history, USCIS can take that and use it as a reason to say that you don't have good moral character because you did not disclose certain criminal history. So it's really important that when you're looking at whether you qualify for the good moral character requirement, not only are you looking at criminal history, you're looking at other things too, like even if you do have a criminal history, have you been rehabilitated? How is your relationship in your community, right? Are you volunteering for things? Are you, like, for example, are you coaching a little league team? Are you super involved in the activities that your kids are doing, that you're able to get letters from community members that are able to basically testify to you having good moral character despite your criminal records? Okay, so there's so many things that you can do, other than the rap sheet, to show good moral character. However, USCIS wants to see your criminal records. Okay, they want to see that you did an FBI background check and that you are good. That's what they really want to see. You can use the letters from the community as extra, right? I'm sorry, that's extra, right? Unless you have something on your criminal background that you need to show that you are still a good person despite that thing, do they really, the letters are not going to be as persuasive as an FBI background check. That's just been my experience. Now, the big requirement. So after you meet all of those ones, now the biggest requirement, the reason VAWA exists, is that you were subjected to battery or extreme cruelty by your US citizen or permanent resident spouse during the qualifying relationship. Okay? During the qualifying relationship. So this requirement has not changed. So if you two got married and the abuse took place before you got married, that's not during the qualifying relationship. Okay. If you two got married and then got divorced, a year after you got divorced, you were abused by your ex husband, ex spouse, that's not during the qualifying relationship. So the abuse has to take place during the qualifying relationship. So while you two were still married, the abuse took place. Okay. So battery is typically physical violence, right? If there's physical violence, that's battery. Extreme cruelty, like I said, it can be emotional abuse, financial abuse, sexual abuse. Like, there's so many things that happens that falls into abuse that could lead to you being able to apply for VAWA. I do have a whole video where I talk about the different types of abuse and really break down what they are, by going through the abuse um, will. And so, if you want to know more about what could count as abuse, um, from my experience, go ahead and watch that video. It's very detailed. So, I think that would be a useful resource for you if you want to learn more about what actually counts as abuse during the qualifying relationship. Okay, that has not changed. The only thing that has changed are, one, the relationship, right? The living together, right? Residency requirement. Living together does not have to take place during the qualifying relationship. It does have to take place at some point, but it doesn't have to take place during the qualifying relationship. Okay. So it can take place before the qualifying relationship, a bit after the qualifying relationship, but either way, it has to take place before you file for VAWA. So you cannot file for VAWA if you and the person never live together. Sorry, folks. That's the rule there. Even though there's a major change in that requirement, but it still requires you to have lived together at some point. And USCIS, if you look at their policy manual, they specifically say that visiting each other, it does not qualify as living together. Okay? Living together means you literally change where you live, right? This is now your home. This is where you put on all your documentations that you're residing. So it's not somewhere you go just for a weekend or, every other weekend. This is your home. So if you do move in together, even if you were moving in together, it only lasts like 3 days and you are just like, this is too much, I can't, and you leave, that still counts as residing together. However, if you were just going there for a weekend visit, that does not count as residing together. So it's really important that we break down that word, residing together, because even though the change doesn't require you to now reside with your abuser during the qualifying relationship, it does require you to reside with them at some point. So that is what I have for you today. If you have any questions, go ahead and put them in the comments. If you would like to schedule a time to speak with me, you can do that. All my contact information is in the description to this video. And as always, thank you. And if you like this video, go ahead and hit the like button. If you know someone who needs to hear this and you really want to share it with them, go ahead and share this video with them. And if you are listening in a place where you can subscribe, go ahead and hit the subscribe button. And once again, I am Lilian Chukura. I am the owner of Lily Legal, where we do immigration law and we do it well. Bye for now.